Good evening.
Good evening.
Okay. Welcome to Who Wants to Be a Millionaire LTD edition. Okay.
Woo!
Yes. Woohoo! I'm your host for tonight. I am Tito Patrick. And
I'm Abee.
yes. Okay. Abby, since LTD is a very interesting topic, we will make it more interesting by playing a game. Okay.
Yeah.
Yeah, we will play Who Wants to Be a Millionaire. Okay. Our topics for today are non-registrable properties, publication, opposition, and default. Okay. Abby, the mechanics are very simple. We have 13 rounds consisting of 13 questions, so one question each. So you have to answer all the 13 questions for you to win an imaginary $1 million. All right. Ganun kalaki. Are you excited, Abby? Are you excited?
Yeah, when I heard the term imaginary, I got disappointed.
Oh, syempre wala tayong budget, so imaginary lang muna, okay? But ang
Okay.
importante, we will
For the
answer.
sake of knowledge.
Yeah, of course.
Okay,
Abby,
let's do it.
okay. Are you ready, Abby?
Yeah. Yeah, I'm so ready.
Okay, okay. Let's play. Your first question for $500. Which of the following does not form part of the public domain? A. Waters rising continuously or intermittently on lands belonging to private persons, to the state, to a province, or to a city or a municipality from the moment they leave such lands. B. Continuous or intermittent waters of springs and brooks running in their natural beds and the beds themselves. C. The wastewaters of fountains, sewers, and public establishments. Or D. Man-made lakes and lagoons formed in private establishments. Abby, what's your answer?
The answer is letter D. Man-made lakes and lagoons formed in private establishments.
You answered letter D. Abby, for
Yes,
500.
letter D.
Okay, for $500. Are you correct?
Imaginary dollars.
Yes, it's only imaginary. Okay. The correct answer is. Good job. Good job, Abby. Okay. Beginner's luck. Okay. Do you want to share about your answer?
Yeah, sure. Well, because I think the civil code provisions dealing with special properties provided an enumeration for lands which belongs to the public domain, and among those enumeration, it does not include the man-made lagoon. It only includes the rivers, continuous and or intermittent waters, springs, waters rising continuously or intermittently on lands of public domain, and such other things. But I'm so sure that it does not include the man-made lagoons, man-made lakes and lagoons in the answer, which is letter D.
Okay. Thank you, Abby. That's a wonderful explanation. Okay. We'll now move on to round 2. Abby, for $1,000. Properties of public dominion are held by the state by virtue of what principle? A. Paris Patriae. B. Regalian Doctrine. C. Res Publicae. Or D. Right to a balanced and helpful ecology. Abby, what's your answer?
The answer is letter B, Regalian Doctrine.
Your answer is letter B, legal and doctrine. Are you sure?
I'm so sure.
Let's find out if you're correct. Nice, okay. The correct answer is legality and doctrine. Okay, so do you have anything to add?
Do you want me to explain? Regalian doctrine means okay. So, far as I can remember, in the case of Republic versus Alagad, the court said that properties of public domain are held by the state by virtue of the Regalian doctrine. So that's what I remember. I didn't remember the rest, but that's what I remember from that case. So I'm so sure of my answer. And luckily, I'm correct.
Okay, thank you. Thank you very much for remembering. Good job. Abee, are you ready for our next round?
Yeah.
Okay. So Abee, you now have a total of $1,000. So round 3.
Imaginary dollars.
Yeah, imaginary. Again, imaginary that. Ako, baka mag-abono pa ako. Okay. Round 3 is worth $2,000. Okay. So this is your question. Which of the following has exclusive prerogative in the classification of public lands? Ooh, this is pretty easy. A, the legislative department. B, the executive department. B, the judicial department. Or D, register of deeds. Okay, Abee, what's your answer?
Of course, it's letter B, the executive department.
Are you sure?
Yeah.
How about letter D?
I'm so sure because I answered this in our final exams, I think, in second year in LTD. So I'm quite sure because I'm wrong that time. So I am so positive that the answer is letter B. Right now, I don't want to make the same mistake again.
Alright, so let's see if you're correct, Abee. Your answer is letter B, the executive department. The correct answer for $2,000 for an imaginary $2,000. The answer is executive department. I'm sure your professor in LTD will be proud. Okay.
Yeah.
Yeah. Okay. Abee, we'll now move on to the next round. But before that, do you have anything to add or to explain in your answer?
Yeah, I would like. Okay, I will just explain about the prerogative of the executive because, as held in the case of Bureau of Forestry versus the Court of Appeals, so the classification of public lands is an exclusive prerogative of the executive department of the government and not of the courts. In the absence of such classification, the land remains as unclassified land until it is released therefrom and rendered open to disposition. Okay,
so what is required in this act? Is there a required order from the president?
The law just says that the government must have a positive act. So whether it is a proclamation or an act or a rule or an IRR, it just needs a positive act from the government.
Okay, so let's see. Actually, it is connected in the next question. So.
Oh my God, you just gave me a clue.
Well, ginano ka bait.
Spoilers.
The next round is worth $3,000. The question is fill in a blank, Abee. Blank is needed to declassify land which is classified as forest and convert it into alienable or disposable for agricultural or other purposes. A positive act by the government. B, a court judgment. C, assessor certification. Or D, none of the above? Abee, for $3,000. What is your answer?
My answer is letter A, positive act from the government.
C? It is connected, right? Okay.
Yeah.
Okay, so let's just affirm if you are really correct. Okay. The correct answer, Abee, is. Good job,
I told
Abee.
you so.
Okay. Care to explain your answer, Abee?
Yeah, so as I've said earlier, a positive act of the government is needed to declassify the land which is classified as forest and convert it into either alienable or disposable land for agricultural or other purposes. The positive act may not be necessarily or it be in a form of official proclamation by the president or an act of the Congress. In the case of heirs of Jose Amunategi versus Director of Lands, in most instances, it may be a form of administrative orders issued by the Secretary of Natural Resources or the Bureau of Forestry. So,
okay,
that's it.
So it is not necessary that it is the president himself would proclaim that such land is already an alienable land. Okay, so it is enough that there is an administrative order from what? From what agency?
From the Secretary of Natural Resources or the Bureau of Forestry.
Okay. Thank you very much, Abee. Let's move
Okay,
on.
no problem.
Let's move on to the next round. The next round is worth $5,000. Abee, when can a forest land of the public domain lose such classification and thereafter be alienable? A. When loggers or settlers may have stripped it of its forest cover. B. When there are no more trees in the forest. C. When the forest can no longer sustain wildlife. Or D. An official proclamation by the government. Abee, what's your answer?
My answer is letter D, an official proclamation of the government.
Are you sure you can use your lifeline?
No, I don't need my lifeline. I'm so sure.
Alright. Let's see. The correct answer is letter D, an official proclamation by the government.
Yay!
Do you have anything to add?
Yeah, because as I've said earlier, you need a positive act from the government. So in your enumeration, the rest is not a positive act from the government. Only letter D, an official proclamation from the president. It was also stated in the case of what's that case that I mentioned earlier? The case of Amunategi versus the Director of Forestry.
All right. Thank you, Abee. Let's move on to the next round. Abee, you now have $5,000. So the next round is worth $7,000. Now, I'll give you a chance. Do you want to move on with the next question? Or iuwi mo na ang $5,000? An imaginary $5,000.
Tuloy na natin. Imaginary. Imaginary lang naman eh.
Okay.
Unless malilibre ka.
I'll think about it. Okay. Alright. So let's see kung hanggang saan ka aabot. Abee, the next round is worth $7,000. Abee, the following are subject to acquisitive prescription, except A, the ownership of a navigable stream or of the bed. B, lands covered by the reservations. C, a watershed established as by executive proclamation. D, patrimonial property.
Oh my gosh. We just learned this in civil review.
Okay, really.
Right? My answer is letter D, patrimonial property.
Mm-hmm. So you're saying that patrimonial property is not subject to acquisitive prescription? Are you sure?
Yes.
Final answer?
Yes, that's my final answer.
Okay. For $7,000, Abby, you are amazing, ha? Grabe siguro yung pag-aaral mo sa civil review, no?
Of course.
Saka marami kang baang stock knowledge sa LTD. Ang galing.
Yeah.
Grabe.
Can you believe?
Yes, of course. Your prof will be proud, okay? And I personally am proud of you. Okay. So, okay. Okay. So, since this is, you're proud that you've learned in LTD, okay? So, lubos-lubosin mo na. Care to explain your answer?
Yeah. So according to Article 1137 of the Civil Code, a person's uninterrupted adverse possession of a patrimonial property for at least 30 years, regardless of good faith or just title, ripens into ownership pursuant to such provision. So the rest you can the rest of your options they can be subject to acquisitive prescription except for patrimonial property. So that's it.
Okay. All right. Thank you, Abby. We'll now move on to the next. Here's your question. Abby, for $10,000, under Section 64E of the Revised Administrative Code, the blank may reserve from sale or other disposition and for specific public uses or service any land belonging to the public domain of the government of the Philippines, the use of which is not otherwise provided by law. I will just have to fill in the blank. The choices are letter A, the Secretary of DNR, B, the Senate, C, the Executive Secretary of DAR, D, or letter D, the President. Abby, what's your answer?
I'm not so sure. Can I use my lifeline now?
Okay. You can use 50-50. You can use call a friend or ask your audience, which is which.
I'm just gonna ask our audience. I'm just gonna try my best. I will answer.
Okay.
I will lifeline anymore.
So you won't use your lifeline. So okay.
Yeah.
Okay.
So I will just leave it to choose letter D, the President.
The President. Okay. So tama ba na hindi ka gumamit ng lifeline? Ito na ba ang Okay. Ito na ba ang end ng iyong $1 million imaginary journey? So I'll find out when Who Wants to Be a Millionaire returns. Ay, wala pala tayong commercial. I'm so sorry. Wala pala tayong TV ads. Wala tayong sponsor. Okay. Tayo lang to. Okay. So Abby, let's find out if you're really correct. Your answer is the President. For $10,000 imaginary dollars, you are alright! Galing!
Oh my God.
Iba talaga ang woman's instincts, no?
Yeah.
Iba.
True.
Okay. Buti lang, hindi ko gumamit ng lifeline. Okay.
Oo nga, di ba?
It's good that you trusted your instinct. Okay. Abby, okay. Do you have anything else to say about your answer?
I actually don't because I really just made chamba. So would you like to do the honor?
Of course, of course. It's just very simple. Okay, it is the president of the Philippines that has competence to reserve by executive proclamation those alienable lands of the public domain for specific public use or purpose.
Okay.
Uh, Simple as that. Okay.
Okay.
So Abby will now move on to the next round. Congratulations. You will now have a $10,000. At this moment, Abby, you have 10,000 imaginary dollars. So the next
Yeah.
question is worth 20,000. Okay. Welcome to round 8. Here's your question. Abby, under Section 23 of the Property Registration Decree, or PD 1529, the following are the modes of giving notice of the initial hearing of the application for land registration. Which of the following is not? A. Publication. B. Mailing. C. Subpoena. Or D. Posting. Abby, what's your answer?
I think the answer is very obvious. It's letter C, subpoena.
Really? Why?
I'll just explain later if I'm correct.
Okay. 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 I'm sorry for that. Okay. Alright, let's find out if you're correct. The correct answer is subpoena. Okay. Now, I'm curious. Why subpoena?
Well, because under the same section, under the property registration decree, after the filing of the application for registration of the title plan, the next step is for the proper RTC within 5 days from such filing, issue an order setting the date and hour of the initial hearing. And according to such section, the only modes of publication of the initial hearing is only 3. That is the publication, mailing, and posting. And there's no such thing as notifying by mere subpoena. So that's why my answer is correct.
Okay. Very well said, Abby. Very well said. Okay. Are you ready for the next round?
Of course.
Okay. Always ready. Abby, welcome to round 9 for 30,000 imaginary dollars. The primary purposes and effects of publication of the notice of application are the following. Except A. To confer jurisdiction over the land applied for upon the court. B. To confer authority to the register of deeds over the land applied for. C. To charge the whole world with the knowledge of the application of the land involved. Or D. To invite interested parties for them to take part in the case and assert and prove their rights over the property subject thereof. Well, this is pretty tough.
Yeah,
Abby?
I know.
Abby, what's your answer?
I think it's letter B.
Letter B.
Yeah. I'm just basing it from my previous answer, so I think it's letter B.
Okay. Your answer is letter B, to confer authority to the register of deeds over the land applied for. Abby, the correct answer is Do you have anything to say?
Of course, because as I've said to you earlier, I just base it on my previous answer. Because in my previous answer, I said that the authority is only conferred to the court and no other agencies will be conferred such authority. So when I noticed that there is a register of deeds, it's already a red flag. So I eliminated it from my choices. So I chose letter B. It's also explained
Oh,
in the case of Benin versus Tuason. You may look it up.
oh, thank you. Thank you. I'll take note of that, Abby. Okay, we'll now move on to the next round. Round 10 is worth $50,000. Abby, what is the meaning of the proviso that publication of the notice of initial hearing in the official gazette shall be sufficient to confer jurisdiction upon the court? A. It means that the requirement of notice by mailing can be dispensed with. B. It means that the requirement of notice by posting can be dispensed with. Or C. Notice by subpoena can be dispensed with. Or D. It means that insofar as publication is concerned, there is sufficient compliance if the notice is published in the official gazette. Abby, what's your answer?
I think it's letter D. Letter D, dog.
Really?
Yeah.
You sure about that?
Yes, I'm so sure.
For sure. Okay. Abby, the correct answer for round 10 is good job. Do you have anything to add?
Yeah, it's also cited kasi in the case of Republic versus Marasigan. It says that the proviso was never meant to dispense with the requirement of notice by mailing and posting. It simply means that insofar as the publication is concerned, there is sufficient compliance if the notice is published in the official gazette, although the law mandates that it be published once in the official gazette and once in the newspaper, in general circulation in the Philippines. So that's it.
Okay, so is that all, Abby?
Yeah, that's all I can say. I haven't memorized the whole case, so.
Okay, so what do you think that in the official gazette there is already considered a sufficient compliance of the publication, but how about in a newspaper of general circulation? Is that a sufficient compliance?
No.
Really? Why?
Because I just don't think that it will be enough in a newspaper of general circulation in the Philippines.
It's never enough.
Yeah,
according to
never
the Greatest Showman. Okay,
Yes.
It's never enough because this goes to show that the official gazette, being the official publication of the Philippines, we accord such primacy on such official publication. So, kumbaga bigatin ng official gazette kaysa sa isang simpleng newspaper of general circulation. Okay, Abby?
True. Thank you so much, Pat.
New knowledge, right?
Yeah, new
Okay, that's not imaginary, okay? Just to be clear. Okay. Okay, we'll now move on to the next round. We're now in round 11. And we are back. Again, Abby, for 100,000 imaginary dollars. When can the publication be considered as defective? A. When what was published in the official gazette is the description of a bigger lot, which includes the land subject to registration. B. When the actual publication of notice of initial hearing was after the hearing itself. Or C. When was what published in the official gazette is the description of a smaller lot, which includes the land subject of registration. Or D. All of the above. What's your answer?
My answer is all of the above.
Sure? Final answer?
Yes.
Okay.
Yes.
Let's find out. Good job. The answer is all of the above. All of these choices are defective.
Effective.
Yeah, it makes the publication effective. They make the publication effective. Okay, that's according to PD number
PD
1529. Okay, are you ready for our next round?
Yes, of course.
Okay. Abee, you now have 100,000 pesos. You have an option. Either you go forward and try to reach for $1 million, or you can go home with 100,000 imaginary dollars.
Yeah, let's go forward because I'm already home.
Perfect answer, Abee. Perfect answer. I love it. Okay, and for that, we will now move on to
Finally.
round 12. Abee, for 250,000 imaginary dollars, Section 23 of PD number 1529 provides that the Commissioner of Land Registration Commission shall cause a copy of the notice of initial hearing of the application to be mailed to the following, except A, to every person named in the notice whose address is known within 7 days after publication of said notice in the official gazette. B, to the Secretary of Public Works and Highways, to the provincial governor, to the mayor of municipality or the city, as the case may be, in which the land lies. C, the Secretary of the DOST. D, the Secretary of the Agrarian Reform, Solicitor General, Director of Land Management, Director of Mines, Director of Fisheries and Aquatic Resources, as may be appropriate. Abee, it's hard to read, so please answer it already.
I will choose the simplest choice. I think it's the Secretary of the DOS because all the other options are well explained. So I'll choose the simplest one because I think it's wrong.
Oh, okay. So let's see if there is really beauty in simplicity. Okay. Abee, your answer is C, to the Secretary of the DOST. Your answer is is correct. Do you have anything to add?
Well, nothing. Nothing. I have nothing to add.
Okay. So the question itself explains.
Explains.
Okay.
Yeah.
So we will now move on to the 30th round. Abee, this is your question. Abee, there is a technical error here. It's actually worth 500,000 pesos, or I mean $500,000. Okay.
Oh, I thought we're already on the final question.
Okay. Hindi ko alam sa gumawa nito. Okay. Abee, just to make it clear, your round is for 500,000 imaginary dollars. Your question is, under Section 34 of the Land Registration Act, the following can be an oppositor to an application for registration, except A, a homesteader who had not yet been issued his title, but who had fulfilled all the conditions required by law to entitle him to a patent. B. A forfeiture lessee of a public land. C. A purchaser of prior land before the issuance of the patent to him. Or D. Persons who claim to be in possession of a tract of public land and have applied with the Bureau of Lands for its purchase. Abee, what is your answer?
Oh my God, it's so difficult.
Yes, it is. It's worth 500,000 imaginary dollars.
I will go with letter B. A foreshore lessee of a public land.
So you're saying that a foreshore lessee of a public land cannot be an oppositor to an application for registration.
Yes,
Is that your final answer?
that's my final answer.
Okay. Let's find out. The correct answer is good job. The correct answer is letter B, a forced lessee of a public land.
God.
Yes, you just won 500,000 imaginary dollars. Okay. So, do you have anything to add?
Yeah, because I noticed that a mere foreshore lessee of the public land cannot be an oppositor for the reason that he has no equitable ownership of the land yet. So his right is being subordinate to that of the government. That's it.
Okay. So, because why? Why he is not yet
Because he's a mere lessee.
oh, why? Can you define a lease?
Can I not?
Okay, since we have no more time, we'll now move on to the next round. Hindi na kita pahirapan, Abee. Okay, so next round is worth 1,000,000 imaginary dollars. Abee, again, I'll ask you for one last time. You have a choice to go forward, or you can just go home for 500,000 with a $500,000.
Again, I'm already home, so let's just move forward.
Okay. Okay, there's nothing to lose, right?
Yeah.
This is an exciting game, isn't it?
No.
Yes, it's very exciting. Yeah. Okay. I love that we did this. Okay. So this is our last round for 1,000,000 imaginary dollars. Abee, this is your final question. Abee, the choices are pretty long. The following are the effects of a default order in a land registration proceedings, except a person who has not challenged the application for registration cannot own the land. B. All the allegations in the application are deemed confessed on the part of the opponent. C. A person who has not challenged the application for registration of land, even if the appeal he afterwards interposed is based on the right of dominion over the same land, cannot allege the damage against the judgment granting the registration. D. Person who has not challenged the application for registration of land, even if the appeal he afterwards interposed is based on the right of dominion over the same land, can no longer allege error against the judgment of application for registration. I guess the question is pretty tough. Abee.
Yeah, I'm still thinking about it. Can I answer now?
Since you still have 3 lifetimes, you want to
Can I
use it?
use one? Can I really use one?
I don't think so. I'm just kidding.
Oh, okay.
I'm just kidding.
Okay.
I guess you just have to trust your instincts, because
Okay.
I am really confident that you're gonna answer this question right. So
Okay.
let's go with it. Besides,
I'll
you
go
don't have anything to lose.
True. I'll go with letter A. A person who has not challenged an application for registration cannot own the land.
Are you sure?
Yes.
Final answer.
Yes.
Okay. Abby, for $1 million imaginary dollars, the correct answer is
Oh my god!
Aren't you happy?
Oh
You
my
just
gosh, I
won
am.
$1 million imaginary dollars! Woohoo! Grabe! Congratulations! Parang hindi ka masyadong masaya.
Masaya ako into it. I just can't still wrap my head around it. You know?
Okay. Okay, but before that, do you have anything to add in your answer?
Well, I think because I think a person who has not challenged the application for registration can still, can still gain standing in the court by filing a motion to set aside such order or default in accordance with Section 3, Rule 18 of the Rules of Court. So you may just look that up too.
Okay. All right.
Okay, so
is there any remedy for that person?
that's the relief.
Okay, that's the relief already.
Okay, yeah.
Okay. All right. I guess we're done. You did very well, Abby.
Thank you so much.
You did very well. Congratulations. Okay. So this is your check.
Oh, I have a check.
Yes, I'm just gonna send it to you soon. Okay. Just Abby, again, congratulations. You just won $1 million imaginary dollars. Okay.
Thank you so much.
All right. We learned a lot from you and we enjoyed. Okay. Thank you very much.
Thank you so
Okay.
much.
Okay. Guys, this has been your host, Tito Patrick. See you again in our next edition. Who Wants to Be a Millionaire? LTD edition. Good evening, civilists. Welcome to another episode of Who Wants to Be a Millionaire? LTD edition. I am your host, Tito Patrick, at your service. And today, another person will attempt to win $1 million imaginary dollars. Kanina, ginalingan ni Abby. She won $1 million imaginary dollars. Matatapatan kaya ng taong to ang galing ni Abby or uuwi siya ng luhaan? Correction, nakauwi na pala siya. Guys, please welcome Miss Marizeta AURO.
Hey everyone! How are you? Hi, Tito Pat! How have you been?
Hello, I'm good.
Are you ready for this round, huh? To host this round in
Of course.
Who Wants to Be a Millionaire?
I am so ready, okay? Are you ready to win $1 million?
I would love to try to win an imaginary amount of $1 million.
Okay, that's the spirit. Zeta, we have the same mechanics, okay? We have 14 questions and 14 rounds. So you get all the answers correctly, you will get $1 million imaginary dollars. Okay? So our topics for today are evidence, hearing, judgment, and post-judgment incidents in ordinary land registration. Zeta, are you ready to play?
Tito Pat, I'm very ready to play.
All right, let's play. Zeta, this is your first question. Zeta, for $500, which among the following is a proof that land has been declassified from the forest zone, thus is alienable or disposable? A. Title of a fish pond that was previously a residential land. B. Recommendation of the district forester for release of the land from unclassified origin. D. A survey plan approved by Bureau of Lands. Or D. Reports and testimonies of a district forester and the land inspector. Zeta, A, B, C, or D? What's your answer?
Tito Pat, I think my best answer would be letter D.
Letter D. Reports and testimonies of a district forester and the land inspector. Is that your final answer?
Yes, Tito Pat.
Alright. Let's find out if you're correct. The correct answer is... Congratulations. You just won $500 imaginary dollars. Congratulations. Do you want to elaborate on your answer?
Yes, of course. Tito Pat, my answer is letter D because it was actually decided by the Supreme Court in the case of the Director of Lands versus Court of Appeals that the Supreme Court gave weight to the mere certification of the Bureau of Forestry that the land applied for became disposable and alienable only on April 28, 1961. Hence, among the choices, the one that is proof of evidence in land registration proceedings is letter D, which is reports and testimonies of a district forester and a land inspector.
Okay, well said. Thank you, Zeta.
Thank you as well.
Zeta, we're now on round 2. Zeta, for $1,000. Here's your question. Zeta, which among the following is not a proof that land has been declassified from forest zone, thus is alienable or disposable, and is registrable? A. Presidential proclamation. B. Executive order. C. Administrative order issued by the Secretary of Environment and Natural Resources. Or D. None of the above. What's your answer?
I think all these choices, such as A, B, and C, are proof that the land has been declassified from the forest zone. Thus, my answer would be letter D, none of the above.
Letter D, none of the above. Is that correct? Let's find out. The correct answer is letter D. Good job, Zeta.
Thank you.
Do you have anything to add to your answer?
Yes, according to the case of Sunbeam Convenience versus Court of Appeals, before any land may be classified from the forest groups and converted into alienable or disposable land for agricultural or other purposes, there must be a positive act coming from the government. And all those choices that we mentioned, such as letter A, presidential proclamation, the executive order, which is also a positive act of the president, and C, administrative order issued by the Secretary of the Department of Environment and Natural Resources, are all positive acts from the government. Hence, my answer was none of the above.
All right. Thank you. Thank you, Zed.
Welcome.
Are you ready for the next round?
Thank you for 1,000 imaginary dollars.
We'll now move on to the third round. Zeta for 2,000 imaginary dollars. Which among the following evidence may establish that the land is public grazing land within a forest reserve? A. Land classification map of the Bureau of Forestry indicating timberland. B. Presidential proclamation reserving area for wood production, watershed, soil protection, and other forest uses. C. Pastoral lease agreement with the Bureau of Forestry. Or D. All of the above. Zeta, what's your answer?
Let me think about this one.
Take your time.
I guess all these are correct. So these choices are all evidence that may establish that a land is public grazing. It's one that is a land of public grazing and within a forest reserve. Hence, my answer would be letter D.
Okay. Zeta's answer is letter D. Correct. You are correct. All of these are evidence that is the land is public grazing land within a forest reserve.
Tito Pat, if I may just add,
Mm-hmm.
in this question of yours, that question was already actually decided by the Supreme Court, wherein it enumerated the lands that was mentioned in the question. In Director of Lands versus Rivas, the court held that the following evidence may establish that the land is public grazing land within the forest reserve. Land classification map of the Bureau of Forestry indicating timberland, presidential proclamation reserving area for wood production, watershed, soil protection, and other forest uses, pasture lease agreement with Bureau of Forestry, tax declaration describing land as for pasture exclusively, or even simply describing it as pastoral land, and possessory information title describing land as grazing land.
Well said. Well said, Zeta. Thank you.
Thank you.
We'll now move on to the fourth round. Zeta for 3,000 imaginary dollars. Section 1858 and 1864 of the Revised Administrative Code and Section 26 of Act 496 require the presentation of tracing plot land. The question is, when may an applicant in a land registration case not present the same? A. When the correctness of the survey plan had not been overcome by clear, strong, and convincing evidence. B. A survey plan is presented. C. When a blueprint is presented instead. Or D. When a survey by the Bureau of Lands is presented instead. Zeta, what's your answer?
I think, Tito Pat, my best answer would be letter A. When the correctness of the survey plan had not been overcome by clear, strong, and convincing evidence.
Okay. You sure?
Yes, Tito Pat.
So
For 3,000, yes, Tito Pat. For 3,000 imaginary dollars, I would like to know if my answer is correct.
Okay. Your answer is correct. An applicant in the land registration fees need not present the same if the correctness of the survey plan had not been overcome by clear, strong, and convincing evidence. Do you have anything more to add?
Yes, Tito Pat. Actually, in the case of Director of Lands versus Intermediate Appellate Court, the Supreme Court acknowledged that the presentation of the tracing cloth plan required by sections 1858 and 1864 of the revised administrative code may be dispensed with where there is a survey plan and the correctness of which had not been overcome by clear, strong, and convincing evidence.
Okay. Thank you, Zeta. We'll now move on to the next round. Zeta for 5,000 imaginary dollars. The following are proofs of private ownership, except A. Spanish titles in land registration proceedings filed after August 16, 1976. B. Tax declaration and realty tax payments. C. Presidential issuance and legislative acts. D. Original certificate of title. Zeta, what's your answer?
I think all these are proofs of private ownership for purposes of land registration proceedings. However, I'm having doubts with letter A. So I think my best answer would be letter A, Spanish titles in land registration proceedings filed after August 16 of 1976.
Your answer is letter A. Okay. Let's find out if you're correct. Nice. Well done. Do you have anything to add?
Yes, Tito Pat. Spanish titles such as those that are composición con el estado, título real, información posesoria, and título de compara or the like are now inadmissible and ineffective as proof of ownership in land registration proceedings filed after August 16, 1976. This is pursuant to PD number 1529, section 3 of the same. Hence, my answer was correct that it is A, Spanish titles and land registration proceedings filed after August 16, 1976.
All right. I'm impressed.
Thank you, Dapat.
Are you ready for our next round?
Very much ready.
Okay. Next round is worth 7,000 imaginary dollars. Zeta, which among the following is a sufficient proof to establish private right or ownership? A. A compromise agreement among the parties to a land registration case. B. A decision in an estate proceeding of a predecessor in interest of an applicant. C. A survey plan of the land approved by the Bureau of Lands. And D. None of the above. Zeta, what's your answer?
Tito Pat, my answer would be letter D, none of the above.
Really?
Yes, because I feel like a compromise agreement, a decision in an estate proceeding and a survey plan are not sufficient proof to establish private right of, or rather ownership.
Really? Well, what do you think is sufficient? But before you answer that, let's find out if you're correct. Okay? Alright. You're correct. So, here to explain your answer?
Yes, Tito Pat. Actually, my answer was based on 3 jurisprudence decided by the Supreme Court. In Republic versus Zeta, it was held that a compromise agreement among the parties in a land registration case is no proof of title at all without further factual proof of their ownership. And in the case of Director of Lands versus Intermediate Appellate Court, the Supreme Court held that the decision in an estate proceeding of a predecessor in interest is no proof of title of the same. And lastly, in the case of Republic versus CA, it was held that a survey plan of the land, even if approved by the Bureau of Lands, is no proof in itself of ownership of the land covered by the plan. Hence, these are not sufficient as evidence in land registration proceedings.
All right, you're correct. It is none of the above. Well said. All right, Zeta, let's move on to the next round. Zeta, the next round is worth 10,000 imaginary dollars. Okay, so this is your question. Zeta, for 10,000 imaginary dollars in the computation of time necessary for prescription, the present possessor may complete the period necessary for prescription by tacking his possession to that of his grantor or predecessor in interest. The question is, when does this apply? A, only when there is privity between the successive possessors. B, only by a good will or only by virtue of a good will of the original possessor. C, by reason of gratuity. D, none of the above. What's your answer?
I think, Tito Pat, my best answer would be letter A, only where there is privity between the successive possessors. Yes, Tito Pat, because I think for the computation of time necessary for prescription, tacking may only be affected if there is privity among the between the present possessor and the successive possessors by reason of, say, for example, succession, lease, or those things.
Let's find out if you're correct. Zeta, your answer is letter A. And the correct answer is none of the above. Why is it none of the above?
Actually, I think I don't know.
Okay.
I think there's a glitch in the system. I
believe so. Zeta,
could you explain why?
Okay. In the computation of time necessary for prescription, the present possessor actually may complete the period necessary for prescription by tacking his possession to that of his grantor or predecessor in interest. It only applies when there is privity between the successive possessors. Okay, that is according to jurisprudence. Okay, Ruiz versus Court of Appeals. I believe that there has been a little glitch. So
that's correct, because actually the case you cited also cited Resote versus Resote and Loxin versus government. So I think that's just a little glitch in the system that we are using, and I feel like the correct answer is letter A, only where there is privity between successive possessors. That's very clear, right?
Yeah, yes, you are.
Thank you, Tita Pat.
I apologize for the technical glitch. Okay, so Zeta, you still won how much? You won $10,000. Okay, so the next round is worth 20,000. So, are you ready for the next round?
Yes.
Okay.
I'm very much ready.
Okay, let's move on. Zeta, for 20,000 imaginary dollars. The question is, for purposes of registration, the following are sufficient proof of possession, except occupancy by grazing livestock, B, cultivation of plants in the subject land, C, declaring uncultivated land for taxation purposes, or D, none of the above. What's the answer? Check.
Tito Pat, my best answer would be, this time, letter D, none of the above.
Are you sure?
I am sure.
Okay, let's see. The correct answer is. The answer this time is really none of the above. Okay.
Tito Pat, actually, would you mind if you explain why the correct answer is none of the above?
Yes, of course. Aside in the case of the public versus intermediate appellate court, while grazing livestock over land is, of course, to be considered as other acts of dominion to show possession, the mere occupancy by grazing livestock upon it without substantial enclosures or other improvement is not sufficient to support a claim of title through acquisitive prescription. And on the contrary, it merely showed casual or occasional cultivation of portions of land in question. In short, possession is not exclusive nor notorious, much less continuous, so as to give a presumptive grant from the government. And the mere fact of declaring uncultivated land for taxation purposes and visiting it every once in a while does not constitute acts of possession. That is cited in the case of Director of Lands versus IAC.
Tito Pat, thank you so much for explaining
Yeah. Did you
the
like
correct
it?
answer. Yes, Tito Pat, thank you so much.
Okay. I love it actually. Okay, thank you for the effort. Thank you for my effort. Okay, let's now move on to the next round. We're now in round 9 for 30,000 imaginary dollars. Zeta, your question is fill in the blank. Section 23 of PD 1529 provides that the court shall within blank from filing of the application issue an order setting the date and hour of the initial hearing, which shall not be earlier than 45 days nor later than 90 days from the date of the order. A. 5 days, B. 10 days, C. 15 days, or D. 20 days. Zeta, what's your answer?
It's very tricky because this talks about periods and I rather days. But I think my best answer would be letter A, 5 days.
5 days. So the 5 days that the court shall issue an order within 5 days from the filing. Okay, that's your answer.
Yes, Tito Pat.
Okay.
I believe so.
Sign out if you're correct. Zeta, the correct answer is. Okay. Congratulations. I mean, Zeta, do you have anything to add to your answer?
The correct answer is 5 days because as provided in section 23 of the cited case, the court shall within 5 days from the filing of the application issue an order setting the date and hour of the initial hearing, which shall not be earlier than 45 days nor later than 90 days from the date of the order. Furthermore, the rule adds that the public shall be given notice of the initial hearing of the application for land registration in either of the 3 means, which are publication, mailing, and posting.
Okay. Thank you, Zeta.
Welcome.
So Zeta, as of now, you have 30,000 imaginary dollars. Okay, so you have an option. You can go on and still fight for that imaginary $1 million, or you can go home with 30,000 imaginary dollars without the risk of losing. So what is it?
You know what, Tito Pat?
What?
My motivation is my motto.
What is your
which
motto?
which is to power through until the very end.
All right.
That's why I would like to continue this game and
All
achieve
right.
1 million imaginary dollars.
All right, I can feel your excitement. That's the spirit. Zeta for 50,000 imaginary dollars. Section 27 of PD number 1529 requires the trial court in registration proceedings to dispose of the case within how many days from the date of submission thereof for decision? A. 60 days. B. 40 days. C. 120 days. Or D. 90 days. What's your answer?
To Pat, my answer would be letter D, 90 days.
For sure.
Yes, Tito Pat.
Okay. Let's find out. You're correct. Zeta, the correct answer is do you have anything to add with your answer?
Yes, Tito Pat. According to Section 27 of PD number 1529, the trial court is required to dispose of the case within 90 days from the date of submission thereof for decision. Hence, my answer was 90 days.
Okay. Thank you, Zeta. We'll now move on to the next round. Okay. Zeta, for this round, what is at stake is already a big amount. 100,000 imaginary dollars. So, good luck. The question is, which among the following is not an element of res judicata in land registration proceedings? A. The formal judgment must be final. B. There must be between the first and second actions identity of parties, of subject matter, and of cause of action. C. It must be a judgment on the merits. Or D. It must have been rendered to any court in the Philippines. Zeta, what is your answer?
Tito Pat, I think my best answer would be letter D. It must have been rendered by any court in the Philippines.
Okay, so that is your best answer. How about your worst? Do you have any worst answer?
I think, of course, letters A, B, and C are in equal footing of becoming worst answers because I excluded them from my answer.
Okay, good answer. Good answer. Okay, let's find out if you're correct. Okay, Zeta, the correct answer for 100,000 imaginary dollars is alright. Good job. Okay, so the correct answer is letter D. Do you have anything to add or explain, Zeta?
Yes, Kuya. Yes, Tito Pat, was held in the case of Vencilao versus Bano and a lot more other cases. The principle of res judicata applies to all cases and proceedings, including land registration and cadastral proceedings. Henceforth, the case stated the 4 requisites that must concur for res judicata to apply. First, there must be a former judgment that is final. Second, the judgment must have been rendered by a court having jurisdiction of the matter and of the parties. Third, it must be a judgment on the merits. And fourth, there must be between the first and the second actions identity of parties, of subject matter, and cause of action. Hence, my answer was letter D because a decision rendered by any court in the Philippines is not an element of res judicata, but as may be gleaned in your screen, the decision must have been rendered by a court having jurisdiction of the subject matter and of the parties.
Okay. Oh, well said. Zeta, this is your next round. Zeta, we are now on your 12th round for 250,000 imaginary dollars. Which among the following is false? A. Even only a portion of the land subject of registration is contested, the court may render judgment. B. A land registration court has no jurisdiction to adjudge a land to a person who has never asserted any right of ownership. C. Portions of land covered by public land patents should be subject of separate litigation, or letter D, none of the above. Zeta, what's your answer?
Tita Pat, my answer would be letter D, none of the above.
Really?
All these are correct. All these are true for me.
Okay. I'm curious about your basis, but let's find out first if you're correct. So, Zeta, the correct answer is? Okay. So, I want to hear your thoughts.
As I've told you earlier, all those choices, A, B, and C, are true statements or correct statements because, as provided for in PD 1529, in section 28 thereof, even only a portion of the land subject of registration is contested, the court may render judgment. Further, in a catena of cases, such as Almarza versus Argelius, Vida de Recinto versus Inchong, and a lot other more, a land registration court has no jurisdiction to adjudge a land to a person who has never asserted any right of ownership thereof. And further, as held in the case of Director of Land versus Court of Appeals, portions of a land subject of a land registration case are covered by titles based on homestead free or sales patent, and the court cannot simply invalidate them even if applicant's evidence establishes his right ownership of those titled portions. So that's my answer to that.
Thank you for your eloquent explanation, Zeta. We'll now move on to the next round.
Oh, I'm very much excited, Tito Pat. I move forward to getting 500 imaginary. I mean, it's 500,000 imaginary dollars.
Okay, I know you're excited, but I'll give you another chance, Zeta. Since 250,000 imaginary dollars is already a big amount of imagination, I'll give you a chance to decide if you want to go home already and be with your 250,000 or move forward and attempt to win the $1 million, but there is already a risk of losing. Okay, so what is it, Zeta? Uurong or susulong?
You know, Tito Pat, I'm actually in the quandary of pursuing this because I'm very hungry right now. But as I've said a while ago, I would like to stand by my motto to push through and power through until the very end so that I may be able to go home with my 1 million imaginary dollars.
All right, that's a spirit, Zeta. I love it. I love it. Although medyo mababa na yung energy ko, pero dahil gusto mo pang tumuloy, eh wala naman akong choice. Tutuloy tayo. All right, let's now move on to your $500,000 question. Zeta, this is your question. Zeta, which among the following is true? A land registration court has jurisdiction over a writ of demolition concerning a subject land. B, a writ of possession may be issued against the person who was being defeated in registration. C, a writ of possession may be issued against anyone adversely occupying the land? Or D, all of the above? Zeta, what is your answer?
Tito Pat, I feel like the best
What do you
answer would be
think?
all of the above. I feel like all these are true statements.
Okay. I'm looking forward to your legal basis, okay? So, but before that, let's find out your answers. Okay. Zeta, for $500,000, you are. You are absolutely correct. All of them are true statements. But I want to hear your thoughts.
As was held in the case of the cases of Lucero versus Loot, heirs of Cristobal Marcos versus de Banovar, and Vencilao versus Vano, and Baltazar versus Caridad, the Land Registration Court has jurisdiction over persons or authority to order, as a consequence of the writ of possession issued by it, the demolition of improvements introduced by the defeated oppositor or his successor in interest. The writ of demolition is but a complement of the writ of possession, without which the latter would be ineffective. Furthermore, in the cases of Vencilao versus Vano, also in Vida de Berroga versus Albano, the Supreme Court held that a writ of possession may be issued not only against the person who has been defeated in a registration case, but also against anyone unlawfully and adversely occupying the land or any portion thereof during the land registration proceedings up to the issuance of the final decree. Hence, the answer is all of the statements were correct.
Okay. Thank you. Thank you for your explanation, Zeta. Whew.
Welcome. Let's go, Tita Pat energy!
Alright, we are now down to our last round. Round 14 is your $1 million imaginary dollar question. Zeta, again, I will give you a chance. Kung urong ka ba o susulong pa?
No sulong-sulong, full of urong-urong. Tita Pat, I'm very ready to get that 1 million imaginary dollars.
Gusto ko yung genuine excitement mo. Gusto ko yung energy mo. Grabe, feel na feel ko yung desire mo to really win the 1 million imaginary dollars. Okay? Okay, dahil napakataas ang energy natin, dahil wala pang exam bukas sa criminal law review. Okay, we will finish this with a bang. Zeta, this is your $1 million question. Zeta, what is the remedy when there is refusal to vacate land despite of a rate of possession? A. Filing a case for contempt of court after initial demand to vacate. B. Filing a case for contempt of court after the second demand to vacate. C. Filing an appeal before the Court of Appeals. Or D. None of the above. Zeta, what is your $1 million answer?
Tita Pat, this is very hard, but I feel like the correct answer is none of the above. I feel like none of these are remedies or is a remedy when there is refusal to vacate land despite writ of possession. I feel like
What?
I feel like it's none of the above.
Okay. Okay, Zeta. Are you sure with your answer?
Very sure.
Okay. You don't want to use any of your lifelines?
No.
Okay. Zeta, one last question. Is letter D your final answer?
Tito Pat. Yes. Letter D is my final answer.
Okay. Would Zeta win $1 million, or she will end up a loser? Let us all find out today. No, na, because Zeta, the correct answer is wow. Amazing. Amazing, amazing, amazing. But before that, I want to hear your thoughts first.
That was the correct answer because under the rules of court, if the judgment for the delivery of possession of real property, the writ of execution must require the sheriff or other officer to whom it must be directed to deliver the possession of the property, describing it to the party entitled thereto. The sheriff must possess or eject the losing party from the premises and deliver the possession thereof to the winning party. Hence, in the case of Quezon versus Philippine National Bank, it was held that it is improper to appeal the case, or it is improper to file a case for a contempt of court before the sheriff executes the writ of execution. But the Supreme Court held that if subsequent to such dispossession or ejectment, the losing part enters or attempts to enter into or upon the real property or ejectment, or in any manner that disturbs the possession of the person adjudged to be entitled thereto, then only then may the loser be charged with and punished for contempt.
Okay. Thank you, Zeta, for your eloquent explanation for your $1 million question. Zeta, congratulations. Well done, well done.
Thanks so
You
much.
just won $1 million imaginary dollars. Okay. Zeta, this is your check. Congratulations.
Thank you. It's with me now.
Okay, so I'm gonna send it to you. Oh, 1, 2, 3. All right. Grabe, iba na talagang technology ngayon, no? Ganoon kabilis. Because your price is imaginary. The
It's
process
in my
of
possession already. Yeah.
the sending is already imaginary too. Okay,
Yeah.
Congratulations, Zeta.
Thank you, Tito Pat. Thank you for this
We
exercise and this
yeah,
opportunity to play Who Wants to
yeah
Be a Millionaire.
we learned a lot about LTD, just like what Abee did. You discussed eloquently your answers. Okay. Thank you very much, Zeta, and I hope to see you again soon. Okay,
Thank you, Tito
congratulations
Pat.
again. All right.